Limitation Act 1963. This act was enacted in order to provide time limit for you to institute a suit. Okay. In criminal procedure code, we have separate provision for limitation, but in civil procedure code, we do not have separate provision like that. That is why we have enacted this limitation act. So, limitation act provides a time limit. Okay. Section 2 has definition clause. Applicant includes a petitioner, any person from or through whom any applicant derives its right to apply, any person whose estate is represented by the applicant as executor, administrator, or other representative. Then we have bills of exchange. Bills of exchange includes hundi and check. In negotiable instrument act, bills of exchange does not include hundi. Okay. Then we have bond, then defendant, easement, good faith. Good faith is important. Nothing shall be deemed to be done in good faith which is not done with due care and attention. Objective question may be asked. Then plaintiff. Plaintiff includes any person from or through whom a person derives his right to sue, and any person whose estate is represented by the plaintiff as executor, administrator, or other representative. Then, period of limitation. Okay, period of limitation means the period of limitation prescribed in the Act, while prescribed period means the period of limitation calculated in accordance with the provisions of the Act. So there is a teeny tiny difference between the two. So period of limitation means the period of limitation prescribed for any suit by the schedule in this act. Okay. Then prescribed period means the period of limitation computed in accordance with the provisions of this act. Okay. Then moving on, part 2, very important, limitation of suits and appeals and applications. Then bar of limitation. This is a general rule. So if you are going to institute a suit and your limitation period ends, then you cannot institute a suit since there is a bar of limitation. But section 4 to 24 is an exception to this general rule. Okay. Next, section 4, expiry of prescribed period when court is closed. Okay, your limitation period ending on the day the court is closed. So what can be done? You can institute a suit when the court reopens. So in that case, the court will extend the limitation period. That is mentioned in section 4. Then section 5, extension of prescribed period in certain cases. This is important. If you have a sufficient cause, court will consider extending the time period, okay, for it to institute a suit. So the question may be asked like, what is the doctrine of condonation of delay or sufficient cause? What is the doctrine of condonation of delay? Condonation of delay or doctrine of sufficient cause? Sufficient cause. If they ask what is doctrine of condemnation of delay or doctrine of sufficient cause, you should mention this section 5. Okay. Then section 6 and 7 says about legal disability. Legal disability means you are a minor, idiot, or unsound mind, then you are suffering from legal disability. So, okay. In that case, if you are suffering from legal disability, you can institute a suit even after the expiry of limitation period. The court will extend the time. Okay. Then if you are suffering from both legal disability, for example, if you are a minor and you are at the time of reaching the age 18, you are suffering from another illness, like you become an unsound person. In that case, after your both disability ends, you can institute a suit. Okay. Then, if you are dead, remaining in a condition of insanity, then your legal representative can file a suit. If your legal representative becomes insane person, then his insanity ends. Then after that, he can file a suit. Okay. Next, section 7 is disability of one or several persons. Okay. So one or several persons are jointly entitled to institute suit, but one of them is suffering from disability. If a discharge can be given without the concurrence of such person, then you can file. One of them can file a suit. But if the without the concurrence of such person, you cannot institute suit. Then you cannot institute suit. Okay, that is mentioned in section 7, disability of one or several persons. Then section 8, special exception that this legal disability is not applicable in case of suit of preemption. Okay. Then continuous running of time. So once the period of limitation begins to run, then no subsequent disability, legal disability stops the time. Okay. So after the period of limitation starts, then you become an insane or unsound person. That will not end the limitation period. Okay. Next, all these rules does not applicable to the suits against trustees and the representatives. Okay. This the suits against trustees and representatives not barred by the limitation period. Okay. Next, suits on contract entered into outside the territories to this act. In that case, if a contract entered outside the territories, the limitation act of those territories is also applicable. Okay. Next, section 12. Okay. Part 3, computation of period of limitation. 12 to 24 provide for computation of period of limitation. Okay. This is also an important part. It has important concepts like doctrine of exclusion of time, doctrine of acknowledgement, doctrine of part payment. So it is a very important part. Please study. Okay. Okay. Section 12, exclusion of time. If they ask what is exclusion of time, doctrine of exclusion of time, you should mention section 12 to 15. Okay. Section 12 to 15. Section 12 is exclusion of time in legal proceedings. Okay. In legal proceedings, what will be the exclusion of time? So, in computing the period of limitation, the day from which the period is to be reckoned shall be excluded. So, the day it starts, the period of limitation starts, can be excluded. Then, in computing the period of limitation, for the suit to review of judgment, then the time period required for obtaining a copy of degree can be excluded. Then, in computing the period of limitation for an application to set aside award, the time period required for obtaining a copy of award shall be excluded. Okay. So, exclusion of time in legal proceedings. Then, section 13, exclusion of time in cases where leave to sue or appeal as a pauper is applied for. Okay. In case of pauper suit, so if you are filing a suit as a pauper, but the court dismissed your application, then the time period required for the pauper application can be excluded, okay, while considering the period of limitation. Then section 14, exclusion of time of proceeding bona fide in court without jurisdiction. So if you are so you have instituted a suit bona fidely in a court that does not have jurisdiction, then the time period required for you to file the suit, and then you have fought the suit. All these period can be excluded while computing the period of limitation. Okay. Next, um, section section 15, exclusion of time in certain other cases. Okay. For example, what are the cases like in computing the period of limitation? Then it has been stayed. Okay. In case of injunction. So the time during the injunction order was made, continuance of injunction, all this can be excluded. And also, if in certain cases, a notice should be given. So in that cases, the period that you have sent the notice, the period that the government has received the notice, all this can be excluded. Then, in case of execution degree by any receiver, the time required by the receiver to institute a suit and the continuance of proceeding, all this can be excluded from the period of limitation. Then, in computing the period of limitation for a suit for possession, the time during which the proceeding to set aside a sale can be excluded. Then, in computing the period of limitation, the time during which the defendant is absent from India can be excluded. Okay, that is exclusion of time in certain other cases. So, if they ask exclusion, doctrine of exclusion of time, you should mention from section 12 to 15. Then we have certain effects, effect of death, effect of fraud and all. Okay. Section 16 mentioned about effect of death on or before the accrual of right to sue. In a case, even before the right to sue arises, the person dies, then the legal representative, if there, when there is a legal representative appears, then from that time the period of limitation can be computed. Okay? This is mentioned in section 60. Then effect of fraud. A person files a suit. Okay, a person files a suit and he provided fraud documents and all. It is not known to the opposite party. Then the time which he discovered the fraud, from that time the period of limitation can be started. So, in case suit is filed on fraud or the knowledge of title is concealed from the court, or the suit or relief is based on the fraud claim, then when the opposite party discovers those fraud or mistake, from that time the period of limitation can be calculated. Okay. Then 18, effect of acknowledgement in writing. Okay, effect of acknowledgement in writing. Okay, before the expiration of period, a person acknowledges his liability by writing that he is bound to pay such sum, or he paid certain sum and certain balance is there. So somehow he has written a certain note acknowledging the liability. Then from that time the period of limitation starts. That is the effect of acknowledgement in writing. Even though there is no time, even though there is no date mentioned, even though there is how much sum he has to provide is mentioned, still the acknowledgement is valid. That is doctrine of acknowledgement. Then effect of payment on account of debt or of interest on legacy. So if he has paid a payment, okay, even before the limitation period ends, then at the time the payment made, from that time the fresh period of limitation starts to begin. Okay, that is effect of payment mentioned under section 90. Then we have effect of acknowledgement or payment by third person. Okay, the effect by payment by third person. Okay? Expression agent, duly authorized, and in case of disability, any lawful guardian, committee, or manager can sign acknowledgement or make payment. That is still valid. Then effect of substituting or adding new plaintiff. Okay, if in a suit a new plaintiff is added, the time period as regard to him will start from the time when he is made party. But if the mistake of not adding such party is bona fide, then the time period will start right from the time when the suit is instituted. Okay. Then section 22, continuing breaches and torts. Okay. The fresh period of limitation will start whenever there is breaches and torts occur. Okay. Then section 23, suit for compensation for acts not actionable without special damage. So without special damage, there is no suit for compensation can be arised. In that case, the time when the special damage occurs, the time period starts to run. Okay, that 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 is the computational period of limitation. Okay. Then part 4, acquisition of ownership by possession. Section 25 and 26 also mentioned in the Easement Act. Okay. We will study about that while talking in Easement Act. Next we have miscellaneous. Miscellaneous. Section 27 is important. Section 27. Section 27 is important. Is extinguishing of right to property. Okay. Extinguishing of right to property. A suit for possession of property shall be instituted within 12 years. Okay, within that period, a person didn't file a suit for possession of property, then his right to institute a suit for such possession shall be extinguished. Okay, this is section 27, extinguishing of right to property. Then miscellaneous, nothing much important. Okay, we have come to the end of Limitation Act. There is a separate schedule providing certain time period for each suit. For example, suit for contracts and suit for torts, all these have separate time period. For example, so for contracts we have 3 years. So for torts we have 1 year. So certain possession of immovable property 12 years, and we have certain limitation period for each suit. So please go through the schedule. Just read it once, you will get a clear cut idea. The questions may be asked in objective questions.